It is a common concern to wonder what happens when you need to step away from work for a while, perhaps for family, health, or other personal reasons. You might naturally wonder if your job will still be there when you are ready to come back. The ability of your employer to refuse your return to work depends significantly on the specific reason for your absence and the various laws that protect certain types of leave. In many situations, especially when your leave falls under protected categories, your employer is legally obligated to reinstate you to your previous or an equivalent position. Many federal and state laws provide important job protections. For instance, the Family and Medical Leave Act, often called FMLA, allows eligible employees to take up to 12 weeks of unpaid, job-protected leave per year for specific family and medical reasons. This includes caring for a newborn child, an adopted child, or a foster child, as well as attending to a serious health condition for yourself or a close family member. If your leave qualifies under FMLA, your employer generally cannot refuse your return and must restore you to your original job or one that is virtually identical. Another crucial protection comes from the Uniformed Services Employment and Reemployment Rights Act, or USERRA. This law protects individuals who perform military service from discrimination in civilian employment and guarantees their right to return to their civilian jobs after their service. Similarly, if you are injured on the job and receiving workers' compensation benefits, most states have laws that grant you the right to return to work once you are medically cleared, often with specific conditions. However, not all leaves are protected by federal or state law. If your leave does not fall under specific legal protections, such as FMLA or USERRA, and you live in an at-will employment state, your employer generally has more discretion. In such cases, if there is no employment contract or collective bargaining agreement specifying your return rights, an employer might legally be able to refuse your return, as long as their decision is not discriminatory. For individuals with disabilities, the Americans with Disabilities Act, or ADA, requires employers to provide reasonable accommodations to help you return to work, unless doing so would cause an undue hardship on the business. This could mean modifying your job duties, adjusting your schedule, or providing assistive technology to help you perform your role. To best protect yourself, it is essential to communicate clearly and in writing with your employer about your leave and your intent to return. Be sure to understand the specific type of leave you are taking and keep thorough documentation related to your absence. Review your company's internal policies and employee handbook, as they might offer additional protections beyond what is legally mandated. If you are ever unsure about your rights or your employer's obligations, seeking advice from a qualified legal professional is a smart step. Understanding these distinct legal frameworks, such as the comprehensive job protections offered by FMLA and USERRA, along with specific state laws, provides a powerful foundation for employees. Even in at-will employment environments, these laws establish clear boundaries, ensuring that your employer cannot simply refuse your return if your leave meets the criteria for protection. Knowing these details helps you confidently navigate your workplace rights. Being proactive and well-informed about your leave rights is absolutely key to ensuring a smooth and successful return to work. Understanding these varied protections empowers you to navigate your employment situation confidently, giving you clarity on when your employer has a firm obligation to welcome you back to your position.